6 months after I had closed on the property on Harmony Road in Springfield, a letter arrived from a finance company in Cincinnati telling me they were going to repossess the manufactured home that sat on my land. The letter said the manufactured home was titled personal property under an Ohio BMV certificate of title in the name of the prior seller, that the finance company held a lien on that BMV title, that the lien had not been paid, and that they were entitled to repossess the manufactured home regardless of the fact that I now held a deed to the land it sat on. They said the manufactured home was not real property. They said it was a vehicle, legally speaking, and they had a lien on it. I am a high school art teacher. I want to describe what it had been like to read the finance company's letter and to identify the moment when I had switched from the stored symbol to the actual thing. The letter had arrived on a Tuesday in October. I had been grading sketchbooks at the kitchen table. I had opened it without particular attention and had read the first paragraph. The stored symbol had activated immediately: debt, lien, repossession, legal threat, panic. I had sat with the letter for a moment and had noticed the stored symbol response the way I notice it in students who draw from symbol rather than from observation. I had set the letter down and had picked it up again and had read it as description rather than as threat. What did it actually say? It said, manufactured home, BMV certificate of title, prior seller's name on the title, finance company lien holder on the title, lien unpaid. These were specific facts about a specific document at a specific government agency. The question was not how to fight the threat. The question was what a BMV certificate of title for a manufactured home meant and what the law said about it when the home was permanently affixed to land that I owned. I had searched for Ohio manufactured home title law that evening. The search had returned Ohio RC 4503.061. I had read it carefully. The statute had described exactly my situation and had provided exactly the remedy I needed. The stored symbol had been replaced by a statute within 2 hours of receiving the letter. The statute had been the actual thing. I had called Adaeze the next morning with RC 4503.061 already understood. Seeing the actual thing is faster than panic. The art instruction had given me that speed. I also want to say something about the specific sequence of the online research and about what had appeared when I had searched for Ohio manufactured home title law that evening. The first results had been general explanations of the Ohio manufactured home titling system. I had read them and had understood the basic framework: BMV title for personal property, county recorder for real property, conversion process for moving from one to the other. Then I had found RC 4503.061 itself at codes.ohio.gov. I had read it section by section the way I read any precise document, from the definitions to the operative provisions to the exceptions. The statute had said exactly what I needed it to say. The owner of real property to which a manufactured home is permanently affixed may surrender the certificate of title to the county auditor. The auditor shall cancel the title. The cancellation shall be recorded with the county recorder. I had read this 3 times to be certain I understood it correctly. I had been the owner of real property to which a manufactured home was permanently affixed. The statute had given me the right to initiate the surrender. I had called Adaeze the next morning with this understanding already formed. The call had been productive because the reading had been precise. The statute had said what it said. I had read what it said. The result had followed from the reading. Override the symbol. Go to the statute. The statute holds the answer. RC 4503.061 is at codes.ohio.gov. Search 4503.061. Read it. It says what it says about who may surrender the title and what the auditor shall do. The statute is short. It is clear. It had been the answer to my specific situation. It may be the answer to yours. Search the statute. The statute holds. Codes.ohio.gov is free and public and searchable. RC 4503.061 is the specific section for manufactured home title conversion. Read it before closing on any property with a manufactured home. Read it after closing if you have already closed and are not certain the conversion was completed. The statute is short. The answer is in it. I found it in one evening. You will find it in one reading. Go read it. Have taught drawing and painting and printmaking in Clark County for 15 years And the skill that art instruction gives you above all others is the ability to look at what is actually in front of you rather than at what you expect to see. When you are learning to draw, your brain substitutes the symbol it has stored for an object in place of the object itself. You draw what you think an eye looks like, rather than what the specific eye in front of you actually looks like. Learning to draw means learning to override the stored symbol and to see the actual thing. The finance company's letter had triggered a stored symbol in my mind: lien, debt, repossession threat. The actual thing in front of me was a manufactured home sitting on land I owned. I had overridden the symbol and had looked at the actual thing. The actual thing had led me to Ohio Revised Code 4503.061. Ohio Revised Code 4503.061 establishes I want to explain more about the Ohio BMV manufactured home title system and about why a manufactured home can be titled as personal property even when it is sitting on a permanent foundation and has been there for more than a decade. Ohio law originally created the BMV title for manufactured homes by analogy to the vehicle title system. Manufactured homes were built in factories and transported to their installation sites and had serial numbers and were in some ways more like very large vehicles than like stick-built homes. The BMV title gave manufacturers and lenders a way to track ownership and security interests in manufactured homes through the central title system. This system made sense when manufactured homes were expected to remain mobile. It made less sense when manufactured homes were permanently affixed to real property with concrete foundations and would never move again. The Ohio legislature recognized this and created the RC 4503.061 conversion process to allow permanently affixed manufactured homes to be converted from personal property in the BMV system to real property in the county recorder and auditor system. The conversion is the legislature's recognition that a manufactured home on a permanent foundation is functionally a house and should be treated as real property. The problem had been that many owners had made the home permanently affixed in every physical sense without completing the legal conversion that the statute required. My prior owner, Patricia, had been one of them. She had put the home on a permanent foundation and had lived in it for 11 years and had never surrendered the BMV title. The physical reality and the legal reality had been completely different things. RC 4503.061 had been the bridge between them. I had crossed the bridge. I also want to say something about why the tax treatment of the manufactured home had been an important supporting fact in the surrender application. Ohio counties can tax manufactured homes either as personal property under the manufactured home tax system or as real property under the real property tax system. Clark County had been taxing the Harmony Road manufactured home as real property for the entire 11 years it had been on the permanent foundation. This tax treatment was visible in the county auditor's records and had been consistent with the home's physical status as a permanently affixed structure. The fact that the county itself had treated the home as real property for tax purposes for 11 years was strong corroboration of the surrender application's core claim. This home was functionally and physically real property, and the BMV title was the only remaining legal instrument that said otherwise. The county auditor who had processed the surrender application had the county's own tax records confirming this. The surrender application had been internally consistent with how the county had been treating the property for a decade. This consistency had made the application straightforward to process. Know how your county taxes the manufactured home on your property. If it is taxed as real property but the BMV title has not been canceled, the county's own records will support your surrender application. The inconsistency between the BMV title and the real property tax treatment is the problem you are solving. The surrender application is the solution. The county's records will help. The physical reality and the legal reality had been separated by one uncanceled certificate. One administrative step. RC 4503.061 had closed the gap. The Clark County Auditor had processed it. The Clark County Recorder had recorded it. The legal reality now matches the physical reality. Both say the same thing. The manufactured home is part of my real estate. The statute made it so. The process by which a manufactured home can be converted from personal property, where it is titled through the Ohio Bureau of Motor Vehicles like a vehicle, to real property, where it becomes part of the real estate and is conveyed by deed. When a manufactured home is permanently affixed to real estate, the owner may surrender the certificate of title to the county auditor. The county auditor then cancels the certificate of title. The surrender is recorded with the county recorder. Once the title has been canceled and the surrender recorded, The manufactured home is no longer personal property at the BMV. It is part of the real estate. It is conveyed by deed. It is encumbered by real property mortgages, not by liens on BMV titles. It is subject to real property law in every respect. The problem with the Harmony Road, I want to say something about what Adaeze Nwosu had told me about the surrender process and about what the application to the Clark County Auditor had required. The RC 4503.061 surrender process requires a formal application to the county auditor in the county where the manufactured home is located. The application must establish that the manufactured home is permanently affixed to real property and that the applicant has standing to surrender the title. Standing extends to the owner of the real property to which the home is affixed, which is what gave me standing despite never having been the BMV titled owner of the home. The documentation we had assembled had been comprehensive. My deed showing ownership of the land, the purchase agreement describing the manufactured home as a fixture included in the sale, a survey confirming the home's position on the property, photographs of the permanent concrete perimeter foundation, photographs showing the absence of wheels and the presence of permanent utility connections, and an affidavit from a neighbor who had observed the home in its current position for over a decade. Adaeze had said that the permanent affixation element was the critical one, and that the photographic evidence of the foundation and the utility connections had been the most persuasive documentation. A home on a concrete perimeter foundation without wheels and with permanent utility connections is not going anywhere. The auditor had agreed. The title had been canceled. The cancellation had been recorded. The finance company's lien had had nothing left to attach to. The process had worked exactly as the statute had designed it to work. The documentation had been the key. Comprehensive documentation produces clean results. I also want to say something about what Adaeze had told me about the finance company's legal position and about why she had said the repossession threat was technically valid before the cancellation and invalid afterward. Before the RC 4503.061 surrender was completed, the finance company held a valid lien on an active BMV certificate of title for the manufactured home. Under Ohio law, a lien holder on a BMV title for a manufactured home has the right to repossess the home in the same way a lender can repossess a vehicle when the underlying debt is in default. The defaulted debt was between the finance company and the prior owner. It was not my debt, but the home was titled in the prior owner's name with the lien attached. My deed to the land was real property law. The finance company's lien was personal property law. The two systems had been treating the same physical object as different legal things. The manufactured home was simultaneously real property for tax purposes, real property for my deed purposes, and personal property for the BMV lien purposes. This legal inconsistency had been the entire problem. RC 4503.061 had been the mechanism for resolving the inconsistency, canceled the BMV title, and the personal property legal status disappears. Once it disappears, the personal property lien disappears with it. The finance company's attorney had confirmed this analysis in the withdrawal letter. They had not admitted it gracefully, but they had confirmed it by withdrawing. The withdrawal was the confirmation. The cancellation had worked. The personal property system and the real property system do not always align for manufactured homes. RC 4503.061 is the legislature's solution to this misalignment. It converts the home from one system to the other. Once converted, the systems are aligned. One deed, one set of rules, one system. The conversion is worth completing as soon as the home is permanently affixed. Do not wait for the finance company's letter. Complete it at closing. Complete the RC 4503.061 conversion at closing. Negotiate it into the purchase agreement as a seller obligation. If the seller cannot complete it, reduce the price by the cost of completing it yourself after closing. The cost is the attorney fee and the recording fees. It is worth accounting for. Do not close without addressing it. I had closed without addressing it. The finance company's letter was the consequence. Address it before closing. The statute allows you to fix it after. Fixing it before is better. Property was that the prior owner had never completed this conversion. The manufactured home had sat on the land for 11 years before the sale. It was permanently affixed. It had been placed on a permanent foundation, connected to utilities, had the wheels removed, and by any observable measure was a permanent part of the property. but the certificate of title at the Ohio BMV had never been surrendered. The BMV still showed the prior seller as the titled owner. The finance company still held its lien on the BMV title. From the BMV's perspective, the manufactured home had never become real property. From the BMV's perspective, the finance company's lien was still valid and enforceable. Before I go on, if this story, I want to say something about Springfield and about Clark County and about what it means to teach art in a county with a manufacturing and agricultural history and a strong working-class identity. The students I have taught in Clark County for 15 years have come from families that work in factories and on farms, and in the healthcare and service industries that a county seat of Springfield's size supports. They have come from families that value practical skill and that have sometimes not understood immediately why drawing and painting are worth a class period in a school day. Part of my work has been demonstrating that the skills art instruction develops are practical: observation, precision, the ability to distinguish between a stored pattern and the actual thing. These are the skills that make a machinist excellent rather than adequate. They are the skills that make a farmer who can read a soil condition rather than assume one. I have said this to my classes many times, and I have come to believe it more completely after the finance company's letter than I had before it. The specific skill of overriding the stored pattern to see the actual thing had been the difference between a panic response and a productive one. It had sent me to the right statute before I had called the attorney. It had saved the manufactured home. Art instruction does not only produce art. It produces the capacity to see clearly in situations where clear seeing is essential. This situation had been one of them. I also want to say something about what the 15 years of teaching art in Clark County had given me as a professional identity, and about how the manufactured home situation had connected to that identity. Teaching art in a public school system is a practice of daily persuasion, persuading students that their capacity to see carefully is worth developing, that the stored symbol is not the enemy, but the baseline from which precise observation departs, that overriding the stored symbol is a learnable skill rather than an innate talent. I had made this argument to hundreds of students over 15 years and had seen the argument work. Students who had arrived unable to draw a hand that looked like anything other than a cartoon symbol had left with the ability to observe carefully and to render specifically. The manufactured home situation had been a test of whether the argument I had been making to students applied to my own situation. It had. The stored symbol for a repossession threat had not been useful. The precise observation of the actual legal situation had been. The observation had found RC 4503.061. RC 4503.061 had protected the property. The property had protected the outdoor studio under the trees. The outdoor studio is the place where I practice what I teach. All of it had rested on seeing the actual thing. The art had protected itself. The outdoor studio under the trees has been active since the cancellation. 7 weeks of uncertainty had not stopped the work. The work had continued because stopping it would have been accepting the stored symbol again. Threat means paralysis. The actual thing meant the work continues while the legal process works. Both ran in parallel. The legal process resolved. The work continues. This is how you live through a legal dispute. Continue the work. Art and law have more in common than they appear to. Both reward precise observation. Both punish substitution of pattern for fact. Both have provided me with tools that worked when the situation required them. The art had taught me to see. The law had provided what I saw. Together, they had held the home. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Celestine. I am 39 years old, and this is the story of how Ohio Revised Code 4503.061, in the process for completing manufactured home title conversion, established what the finance company could and could not do, and what an attorney named Adaeze Nwosu, who had been practicing real estate and title law in Clark County for 13 years, did to protect my property when the finance company came for the manufactured home on my land. Now let me explain the manufactured. I want to say something about the Harmony Road property, and about what had drawn me to it, and about what Patricia's care of it had left for me to work with. I had been looking for property for 2 years before finding Harmony Road. The constraint had been real. A high school art teacher's salary in Clark County does not extend to most of the properties I had wanted. I had wanted land more than I had wanted a particular kind of structure. Half an acre in the rural part of the county, mature trees, space for a garden, and an outdoor studio setup. The manufactured home had been the mechanism that had made the price accessible. It had not been my first choice of structure, but it had been well-maintained and well-positioned and had the specific quality of a home that a person who loved the land had cared for over a long period. Patricia's vegetable garden along the north fence had been planted and organized with the kind of care that takes years to produce. Established perennial herbs along the south edge, a compost area at the back corner, annual beds that had been worked deeply over many seasons. The mature trees at the back of the lot had provided the dappled light I had been looking for in an outdoor studio space. I had made an offer within 2 days of seeing it. When the finance company's letter had arrived 6 months later, I had already planted the first round of bulbs in Patricia's beds and had set up a folding easel under the trees. I was not going to lose the manufactured home that sat at the center of all of this. The statute had given me the means to keep it. I had used the means. The property is mine. I also want to say something about what Patricia had built in the garden and about what inheriting someone else's gardening work means as a practical matter. Her perennial herb border along the south edge of the vegetable beds had been the result of years of selection and division and placement. There was lemon thyme at the corners and sage in 3 varieties, and chives that had self-seeded in the cracks of the stone edging. These are plants that take several seasons to establish themselves the way she had established them. I had not planted them, I had received them. The receipt of established work carries an obligation to continue what was there well enough that it does not die on your watch. I had taken that obligation seriously. The herb border is still there. I have divided the chives twice and added a row of lavender along the outer edge. The compost area at the back corner has been maintained and expanded. The annual beds have been planted each spring. This is what the Harmony Road property had been worth protecting, not only the structure, but the accumulated work of 11 years of someone who loved the land. I love the land now. The statute protected my ability to love it. The garden is still growing. Patricia's time is still at the corners. All of it mine now and all of it hers, still in the way that established gardens belong to the people who established them. I tend it. The statute, let me keep it. I am grateful. Patricia's time at the corners still flowers in early summer. The lavender I added along the outer edge bloomed for the first time last July. The garden is continuing. The statute protected my ability to continue it. The easel is still under the trees. Both of these things matter. Both are part of the same property that the statute protected. I am grateful for both. The perennial herb border is the best part of what Patricia left. 11 years of selection visible in the variety and placement. A person who loved the land built this. I'm continuing it. The statute protected my ability to continue it. Both the statute and the garden reward attention. Pay attention to both. Home title system more fully, and why the distinction between personal property title and real property matters so much for people who purchase land with a manufactured home on it. In Ohio, a manufactured home is initially titled as personal property through the BMV, the same way a car or a truck is titled. The BMV certificate of title shows the owner and any lien holders. A lien holder on a BMV title has a security interest in the manufactured home as a chattel, an item of personal property, and can repossess it in the same way a lender can repossess a car when the loan is not paid. When a manufactured home is permanently affixed to real estate and the owner completes the conversion process under RC 4503.061, this changes everything. The home is no longer a chattel. It is no longer titled at the BMV. The certificate of title is canceled. Any lien recorded on the BMV title becomes unenforceable against the manufactured home once the title is canceled and the conversion is complete, because there is no longer a title to enforce the lien against. The home becomes part of the real estate, and any security interest in it must be in the form of a real property mortgage. The conversion had not been completed. I want to describe what had happened when the Clark County Auditor had processed the surrender application and what the timeline from submission to cancellation had been. Adaeze had submitted the application with the full documentation package to the Clark County Auditor's office. The auditor's staff had reviewed the documentation and had confirmed that the manufactured home was on the county's tax records as real property rather than personal property, which had been consistent with its physical situation on a permanent foundation. This tax treatment had been an important additional piece of evidence. Clark County had been taxing the manufactured home as real property for all 11 years. It had been on the foundation, which was further confirmation that the home's functional status had always been real property, even though the BMV title had never been canceled. The tax treatment and the physical documentation together had made the surrender application straightforward for the auditor. The title had been canceled within 3 weeks of the application. The cancellation document had been issued. Adaeze had recorded the cancellation with the Clark County Recorder the same week. From the date of recording, the manufactured home was legally part of my real estate. The process from my first call to Adaeze to the recorded cancellation had taken 7 weeks. 7 weeks from the finance company's letter to the end of their legal basis. The statute had provided the path. The documentation had supported the application. The auditor had processed it. The recorder had recorded it. The finance company's lien had lost its object. 7 weeks. The problem had been solved. I also want to say something about the 7 weeks from the finance company's letter to the recorded cancellation and about what those 7 weeks had been like to live through. The first week had been the research and the call to Adaeze. The second week had been assembling the documentation package, pulling the deed, finding the purchase agreement, photographing the foundation and the utility connections, locating the neighbor who could provide an affidavit about the home's presence over a decade. The third week had been Adaeze preparing the formal surrender application and her legal analysis. The fourth week had been the submission to the Clark County Auditor and the waiting period while the auditor reviewed the application. The fifth and sixth weeks had been the auditor's processing period and the issuance of the cancellation document. The seventh week had been Adaeze recording the cancellation with the Clark County Recorder and sending the recorded cancellation and the legal analysis to the finance company. 7 weeks of focused work on a problem that had required understanding a specific statute, assembling specific documentation, engaging a knowledgeable attorney, and working through the specific administrative process that the statute established. The problem had been real. The solution had been equally real. The statute had provided the solution. The process had implemented it. 7 weeks. The home is mine. 7 weeks of precise work had been worth it. 7 weeks is not long. But 7 weeks of uncertainty about whether a company could remove the home from my land was a specific and unpleasant experience. The uncertainty is gone now. The cancellation is recorded. The home is mine. The uncertainty had been the price of not knowing about RC 4503.06B1 before closing. Know about it before you close. The price of not knowing is 7 weeks of legal work and uncertainty. Know in advance on the Harmony Road manufactured home. The certificate of title was still active at the BMV. The finance company's lien was still on it. Adaeze confirmed the situation. The finance company had a valid lien on a BMV title that had never been canceled. Their legal position was not frivolous. The title to the manufactured home, from the BMV's perspective, was still in the prior owner's name with the finance company's lien attached. They had a statutory right to pursue that lien. What Adaeze also confirmed was that the solution was available to me as the current owner of the land. Ohio RC 4503.061 allows the owner of the land to which a manufactured home is permanently affixed to initiate the title conversion, even if the manufactured home was not titled in their name. Because I owned the land and the manufactured home was permanently affixed to it, I had standing to complete the conversion that the prior seller had never completed. Adaeze prepared that I want to say something about the Clark County Recorder portal and about what the instrument history for the Harmony Road property now shows. The Recorder portal shows Patricia's original deed from 11 years before her sale. To me, it shows my warranty deed. It now also shows the recorded cancellation of the manufactured home's BMV certificate of title under Ohio RC 4503.061. This cancellation document is the instrument that tells any future buyer, any future title company, and any future lender that the manufactured home on the Harmony Road property has been converted from personal property to real property and is part of the real estate. A future title search will find this document. The question of the home's title status is permanently answered in the public record. Any future buyer of the Harmony Road property will be buying real estate that includes the manufactured home as a legally converted real property component. They will not face the situation I had faced. The work of completing the conversion that Patricia had never completed is now done and recorded and will protect every future owner of the property. The finance company sent a final letter after Adaeze had provided them with the recorded cancellation. The letter confirmed the withdrawal of the repossession threat. It did not apologize. I had not expected it to. The manufactured home is mine. The property is mine. The deed covers both. The recorder says so. The statute made it so. Future buyers will not need to do this work. I have done it for them. The record holds. I also want to say something about what the Clark County Recorder portal shows for the Harmony Road property now and about what future buyers will find when they search it. The portal shows Patricia's original deed from 11 years before she had sold to me. It shows my warranty deed. It shows the recorded RC 4503.061 cancellation document. 3 instruments. The cancellation document is the most important one for future buyers. It tells them that the manufactured home was a BMV titled personal property asset, that the RC 4503.061 surrender was completed, that the BMV title was canceled by the Clark County Auditor, and that from the date of recording forward, the manufactured home is part of the real estate. A future title examiner who searches the portal and finds this document will understand immediately that the conversion has been completed and that the title to the manufactured home is clear as part of the real estate. They will not need to question the BMV status. The question has been answered in the public record. The answer is documented. Future closings on the Harmony Road property will proceed without the manufactured home title issue because the issue has been resolved and recorded. The recorder protects future owners. I did the work. The recorder holds the result. Future buyers inherit the clean title I created. I am glad the statute made this possible. The recorder holds the 3 instruments now. Patricia's deed, my deed, the RC 4503.061 cancellation. Anyone who reads them in order understands the complete ownership and title history of the Harmony Road property. The story ends cleanly. Permanently affixed manufactured home, BMV title canceled, home part of real estate. Clean title, clean record. Future buyers inherit the clean record. This is what the statute was designed to produce. It produced it. Application for surrender of title to the Clark County Auditor. We submitted it with documentation establishing the permanent affixation, the deed to the land, the purchase agreement showing the manufactured home as a fixture included in the sale, photographs of the permanent foundation and utility connections, and affidavits establishing that the wheels had been removed and the home had been in this location on this foundation for more than a decade. The Clark County Auditor accepted the surrender application. The certificate of title was canceled. The cancellation was recorded with the Clark County Recorder. From the date of recording forward, the manufactured home was legally part of my real estate. The finance company's lien, which had been on the canceled BMV title, no longer attached to the manufactured home as personal property because the manufactured home was no longer personal property. Their lien had been on a title that no longer existed. They sent a second letter. Adaeze responded with the recorded cancellation and the legal analysis under RC 4503.061. The finance company's attorney reviewed the situation and withdrew the repossession threat. I want to say something before I go. I want to end with something about the folding easel under the trees and about what it had meant to set it up in the specific light I had been looking for when I had found the Harmony Road property. Outdoor painting in dappled tree light is different from indoor studio painting in controlled light. The light changes. The shadows move. What you are painting at 9 in the morning is different from what you were painting at 8. Because the sun has moved and the angles have shifted, and the specific quality of dappled light through leaves in September is not the same as it had been in August and will not be the same in October. Painting in this light requires the specific attention to the actual thing that the stored symbol cannot provide. You cannot substitute your memory of what dappled light looks like for the specific dappled light that is in front of you at this moment. You must see the actual thing. The easel is still there under the trees. The trees are still there behind the manufactured home that is now legally part of my real estate. The light still comes through the leaves at the angles it came through in September before the finance company's letter arrived. I have continued to paint in it with the specific attention that painting requires. The statute had protected the space where this attention is possible. Adaeze had guided the statutory process to completion. The Clark County Auditor and Recorder had processed the instruments. The finance company had withdrawn. I'm still under the trees. The light is still there. The home is still there. All of it mine now in every legal and physical sense. Override the stored symbol. See the actual thing. The actual thing is always solvable. This was the statute held. I also want to end with something about the morning in early October when I had received the recorded cancellation from Adaeze and about what I had done next. She had emailed me a scanned copy of the recorded document and a short note. The cancellation is recorded. Your manufactured home is part of your real estate. I had read the note at the kitchen table where I had been grading sketchbooks 7 weeks before when the finance company's letter had arrived. I had been grading the same kind of sketchbook assignments, students drawing objects from direct observation, trying to override the stored symbol and to see the actual thing. The recorded cancellation had arrived in the middle of this work. I had set the sketchbooks aside and had walked out to the manufactured home and had stood in the kitchen and had looked out the window at the trees. The dappled light had been exactly what it was, the specific light of a specific October morning, coming through the specific leaves in the specific angles that October produces in Clark County. Not a symbol of autumn light. The actual thing. The home had been mine in that moment in both the physical and the legal sense for the first time. The statute had made them the same. I had gone back inside and had finished grading the sketchbooks. The students who could see the actual thing had drawn well. They always do. See the actual thing. It is always solvable. The statute is there. It holds what the actual thing requires. Go to the statute. It will hold. The statute had been there before I had needed it. The Ohio legislature had designed it for exactly this situation. A permanently affixed manufactured home with an unconverted BMV title. The solution had been available before the problem had surfaced. This is what good statutory design does. It provides the solution before the problem arrives. The statute was there. I found it. It held. Find the statute for your situation. It is likely already there. Ohio law is thorough. Use it. Not about the prior seller who had never completed the title conversion, and not about the finance company whose lien position had been technically valid under the law as it had stood before the conversion. About what the art instruction had given me, and about why looking at the actual thing rather than the stored symbol had mattered in this situation. The stored symbol for a letter saying repossession had been threat, hire lawyer, fight, or pay. The actual thing had been a manufactured home sitting on land I owned, an unconverted BMV title, and a statute that allowed me to complete the conversion. Looking at the actual thing rather than the symbol had sent me to Ohio RC 4503.061 before I had called the attorney. When I had called the attorney, I had called with the question already identified. Adaeze had confirmed the question and had moved immediately to the answer. The art instruction had taught me to see the actual thing. The actual thing had been solvable. The solution had been in the statute. Thank you for staying until the end. I want to say something about what I now tell anyone who is considering purchasing land with a manufactured home on it, and about the specific due diligence steps they should take. First, ask your real estate attorney before closing whether the manufactured home has been converted to real property under Ohio RC 4503.061. Ask specifically for evidence of the BMV title cancellation and the recorded surrender. If your attorney does not know about this process, find one who does. This is a real issue in Ohio manufactured home real estate transactions, and any attorney practicing in this area should be familiar with it. Second, search the Ohio BMV title records for the manufactured home serial number. The serial number is your key to the BMV records. Find it before closing. If the BMV records show an active certificate of title for the home, the conversion has not been completed. Third, ask the seller to complete the RC 4503.061 surrender as a condition of closing. This puts the obligation where it belongs, on the person who originally had the opportunity to complete it and failed to do so. If the seller cannot or will not complete it, negotiate a price reduction that accounts for the legal work you will need to do after closing to complete the conversion yourself. The process is available to you as the landowner. It is not free. It requires an attorney and a documentation package and a processing period. Account for this in the purchase price. Do not close without knowing the status of the manufactured home title. I had not known. 7 weeks of legal work and the threat of losing the home had been the result. Know before you close. The statute will protect you, but the protection is easier to invoke before the finance company sends the letter. I also want to say something about what I tell students when I describe the art instruction principle of seeing the actual thing versus the stored symbol, and about whether they find the principle interesting when applied to situations outside of drawing. The most common response I get from students when I explain the stored symbol problem is recognition. They understand immediately that they draw from symbol rather than from observation, because they can see the gap between their drawing and the thing in front of them. The principle is self-evident once it is named. What the students sometimes struggle to see is that the same principle applies to reading situations outside of drawing, that their interpretation of a school social situation or a conflict or a problem is often a stored symbol rather than a precise observation of the specific situation in front of them. I have started giving them the manufactured home story as an example. I tell them, a letter arrived and I had a stored symbol for what it meant. The stored symbol was wrong. I overwrote it and looked at the actual legal situation. The actual legal situation was different from the symbol and was solvable in a way the symbol had obscured. They listened to this story with attention. The principle lands when it has a specific example. The manufactured home has become my best example of the principle. The principle had protected the home. Now the home teaches the principle. Both are useful. Both will continue to be. I use the manufactured home story in class now when I teach the stored symbol principle. The students find it genuinely interesting that an art principle had protected a house. I tell them, the principle applies wherever you need to see clearly. In drawing, in legal situations, in any situation where the stored pattern obscures the specific facts. Override the pattern. Find the facts. The facts lead to the statute. The statute leads to the solution. This is the principle. The students who learn to see clearly draw clearly. The same skill that makes a good artist makes a good problem solver. The skills are not separate. They are the same skill applied in different contexts. Observation, precision, override of the stored pattern. In drawing and in law, and in any domain where the specific facts determine the outcome. The manufactured home had been saved by the same skill that saves a drawing from being a symbol. See the actual thing. Always. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a man who had purchased a manufactured home community and had found that 7 homes in the community still had active BMV titles in the names of prior owners and what the bulk conversion process under Ohio law had required, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if you purchase land with a manufactured home on it, before you close, ask your title company and your real estate attorney whether the manufactured home certificate of title has been surrendered and canceled through the Ohio BMV and whether the surrender has been recorded with the county recorder. If it has not, the manufactured home is still personal property at the BMV and a prior lien holder may have a valid claim against it regardless of your deed to the land. The conversion process under Ohio RC 4503.061 is your protection. Make sure it is complete before you close, or complete it yourself after closing if the prior owner failed to do it. The statute allows you to do this as the owner of the land. The Clark County Auditor processed the conversion. The finance company withdrew. The manufactured home is part of my real estate. The deed covers it. The statute made it so. I want to tell you more about Springfield and about Clark County and about the Harmony Road property and what it had meant to find a piece of land with a manufactured home on it at a price I could manage on a teacher's salary. Springfield is the county seat of Clark County in west central Ohio, west of Columbus and east of Dayton, a mid-sized city with a manufacturing and agricultural history that goes back to the early settlement of the Ohio interior. The city has the specific character of a community shaped by industry and by the river and creek corridors that run through it, and by the institutions that a century of working-class and middle-class residential life has produced. Clark County has a strong agricultural base outside the city with the specific landscape quality of the western Ohio agricultural plain, flat, productive, organized by county roads and townships in the grid pattern that the original survey of Ohio established. The Harmony Road property had been outside the city limits in one of the residential rural areas of Clark County, a half-acre lot with the manufactured home positioned on the south end of the lot and a large mature tree area at the back. The home had been well maintained by the prior owner, a woman named Patricia who had lived there for 11 years before selling. She had added a large deck on the west side, had put in a vegetable garden along the north fence, and had treated the property with the specific care of someone who has decided this is where they want to be and who has shaped it accordingly. The permanent foundation had been poured before Patricia had moved in. A concrete perimeter foundation with the home set on it, and the wheels removed, and the home tied down according to the installation specifications. The home had the practical character of a permanent dwelling, fully connected utilities, a proper crawl space, a two-car carport on the east side. I had bought it because it was exactly the kind of property a high school I want to say something about what anyone who owns land with a manufactured home should do to verify the title status of that home. The Ohio BMV maintains a searchable title record for manufactured homes. You can search by the manufactured home serial number, which is typically located on a data plate inside the home near the main electrical panel, or in the utility closet, or on a HUD certification label affixed to the exterior. If you do not have the serial number, it should be in the purchase agreement or in the original installation documents for the home. Search the BMV records for the serial number. If the search returns an active certificate of title, the home has not been converted to real property under RC 4503.061. The title will show the most recent titled owner and any lien holders. If there are lien holders on an active title for a home that is permanently affixed to your land, the situation requires attention. You have two options. Contact the lien holder and resolve the lien before initiating the RC 4503.061 surrender. Or initiate the surrender and let the cancellation of the title eliminate the lien holder's ability to enforce the lien against the home as personal property. The second approach requires careful legal analysis because the lien holder may have claims beyond the repossession right. Adaeze had guided me through this analysis and had confirmed that the finance company's only practical remedy had been repossession of the personal property and that the cancellation of the title eliminated this remedy. Get legal advice on this specific situation from an attorney who knows Ohio manufactured home title law. Search the BMV, know the status of the title, act on what you find. I also want to say something about the Ohio BMV manufactured home title search process and about how accessible it is. The Ohio Bureau of Motor Vehicles maintains title records for manufactured homes in the same system as vehicle titles. You can request a title search through the BMV by providing the manufactured home serial number. The serial number is the key identifier for the manufactured home in the BMV system. It appears on the HUD certification label on the exterior of the home and on the data plate inside the home. If you have the purchase agreement from the sale, the serial number should be listed there. A real estate attorney who handles manufactured home transactions regularly will know how to search the BMV records as part of the due diligence process. Ask them to do this before you close. The cost of a BMV title search before closing is trivial compared to the cost of discovering an active lien on an uncanceled BMV title after closing. Adaeze had said that in her experience, most buyers of manufactured home properties in Clark County had never been told about the BMV title search requirement. This is not because their attorneys had been incompetent. It is because the RC 4503.061 conversion process is a specific area of law that not every general real estate practitioner knows well. Find one who does. Ask the BMV question before you close. The question is simple. The answer determines whether you need to do anything before the sale is complete. Ask your real estate attorney about the BMV title search before closing. Ask specifically. Do not assume it is included in the standard title search. It may not be. The standard title search searches county recorder records. The BMV is a separate system. Separately search. One question to your attorney before closing may prevent 7 weeks of legal work after. Ask the question. It is the most important due diligence step for manufactured home properties. If you have already closed and the conversion was not completed, initiate it now. Do not wait for the finance company's letter. The process under RC 4503.061 is available to you as the landowner. The Clark County Auditor processes it. The Clark County Recorder records it. The process takes weeks, not months. Start now. The finance company's letter may never arrive, but the vulnerability is there as long as the BMV title is uncanceled. Cancel it. Art teacher can own on a Clark County salary. modest in price, substantial in space, and a part of the county I had always wanted to live in. I want to say something about the drawing instruction and about what the specific discipline of learning to see rather than to symbolize had produced in my teaching and in my own practice. The fundamental challenge in teaching drawing is that the human brain is extraordinarily good at pattern recognition and at substituting stored patterns for new observations. A beginning student drawing a hand does not draw the hand in front of them. They draw their brain's stored symbol for a hand, a palm with 5 extended fingers, roughly proportional, vaguely anatomical. The result looks like a hand in the way a stick figure looks like a person, recognizable but wrong in every specific detail. Teaching the student to see the actual hand in front of them, to notice the specific angles of the specific fingers in the specific position in the specific light of this specific moment, is the work of years of instruction and practice. The stored symbol is not wrong. It is a useful generalization, but it is not the specific thing. And in drawing, the specific thing is the only thing that matters. I had applied this distinction consistently for 15 years. The stored symbol is the wrong tool for a situation that requires seeing the specific thing. When the finance company's letter had arrived, I had identified it as a stored symbol moment and had switched to specific thing observation. The specific thing had been an unconverted BMV title and a statute that addressed it. The stored symbol would have sent me into panic. The specific thing had sent me to RC 4503.061. I want to say something about what the purchase process had failed to identify and about what I had learned about manufactured home title searches that I had not known before the finance company's letter arrived. When you purchase real estate in Ohio, the title company conducts a search of the county recorder's index and the county court records for liens, encumbrances, and interests affecting the real property. This search identifies mortgages, judgment liens, easements, deed restrictions, and other instruments recorded against the real property. What a standard real property title search does not necessarily include is a search of the Ohio BMV's records for the certificate of title to any manufactured home on the property. The BMV title system is a separate record system from the county recorder. A title company that does not know to search the BMV records, or that searches only the real property records, may not discover that a manufactured home on the property still has an active BMV title with a lien holder. This is what had happened in my case. The title company had searched the county recorder records and had found no liens on the real property. They had not searched the BMV title records. The finance company's lien had been invisible to the real property title search. It had been visible in the BMV system. It had been sitting there the entire time, attached to a certificate of title that had never been canceled, waiting for someone to look. I want to say something about what Adaeze Nwosu had told me about the frequency of this problem and about why the manufactured home title conversion issue is one of the more common and more damaging title defects she sees in Clark County real estate transactions. She had said that a significant proportion of manufactured homes in Clark County that have been permanently affixed to real property for more than 10 years have never had their certificates of title canceled through the RC 4503.061 process. Many of the owners who had gone through the original purchase had not known about the conversion requirement. Many of the real estate attorneys and title companies who had facilitated those transactions had not raised the conversion process as a necessary step. The result had been a large inventory of permanently affixed manufactured homes with active BMV titles still in old owners' names, with old lien holders' interests attached. Every one of those properties was a potential title defect waiting to surface at a future sale or a future lender's demand. She had said the problem was particularly common in rural and semi-rural Clark County, where manufactured housing was a significant portion of the housing stock, and where many purchases had been handled informally or without the title professionals who would have identified the conversion requirement. The remedy was always the same: the RC 4503.061 surrender process. The remedy was available. The problem was that no one had told the owners about it until the finance company's letter arrived.